Hello friends, welcome to our ExamBee's Law Exam channel, Legal Bee. In our last video, we discussed the legal maxim ignorantia juris non excusat and ignorantia facti excusat. And I gave you a situation. In this situation, A was walking on the road when he was approached by B with a gun and B asked him for his purse. A pushed B and ran. Because of the push, B fell on the road, hit a rock, and dies on the spot. Then is A liable, and to which legal maxim this situation relates to? Here we are talking about the legal maxim Actus non facit reum, nisi mens sit rea. There are two important words in this legal maxim. One is actus rea, obtained from actus reum, and the another one is mens rea. Actus rea talks about the action, the criminal act, and mens rea talks about the intention, the bad intention, the criminal mind. And here the entire legal maxim means the act does not constitute guilt unless done with a guilt intent. That means in order to establish a criminal offense, there should be both guilty mind and guilty action, both a criminal act and criminal mind. It means that there can't be a crime without a criminal mind. To hold someone criminally responsible, it must be proven that their actions resulted in an illegal act and that their actions were accompanied by a legally blameworthy mental attitude. As a result, every crime has two components. There is a physical element, which is actus rea, and a mental element, which is mens rea. In our example, A had pushed B in self-defense. B fell on the road and hit his head to the rock. Here, though there was criminal act, though there was actus rea, but there was no mens rea. A did not intend to hurt B. He pushed B only in self-defense, so the element of mens rea was not there and hence he won't be criminally liable for murder. If there would have been an intention of grievous hurt, of death, or injury, then A would have been liable. But here A has acted in self-defense and hence A won't be liable. This maxim can find its importance under Section 14 of the Indian Evidence Act. Section 14 of the Act talks about facts which show existence of state of mind or of body or bodily feeling. So here we are talking about mens rea and it says facts which are showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or goodwill towards any particular person or showing the existence of any state of body or bodily feeling are relevant. So here we are talking about mens rea being relevant when the existence of such state of mind or bodily feeling is an issue or is a relevant fact. So here we are trying to inculcate under Section 14 of Indian Evidence Act the element of mens rea. Also, this principle has been integrated in IPC in two ways. First of all, through the express inclusion of the required state of mind, that is mens rea, in the definition of an offense, and also through general exceptions that are enumerated in Chapter 5 of the Indian Penal Code, some of which are mistake of fact, accident, infancy, insanity, denying the existence of mens rea. So there has been an attempt to inculcate mens rea along with actus rea even in Evidence Act and IPC. This maxim is usually considered in cases where the crime is mala in se, that means wrong in themselves, which is wrong against the society, like murder. Because these crimes require criminal intent, which are different from the crimes which are mala prohibita, which are not wrong in themselves but are prohibited by law. For example, immigrating without permission, staying in a country long without permission, fishing without a license. These crimes do not require a criminal intent. There are certain important case laws with respect to this legal maxim. The first one is Brent versus Wood. In this case, it was held that it is of utmost importance for the protection of liberty of the subject that a court should always bear in mind that unless a statute either clearly or by necessary implication rules out mens rea as a constituent part of the crime, the court should not find a man guilty of an offense against the criminal law unless he has a guilty mind. So in Brent versus Wood, mens rea was formed an essential element, and it was said that unless mens rea is excluded in certain act or in certain offense by law, कोर्ट को ये फॉलो करना है कि क्रिमिनल ऑफेंस में गिल्टी माइंड होना चाहिए. द सेकेंड केस लॉ इज आर वर्सेस टॉल्सन. In this case, the legal maxim actus non facit reum nisi mensit rea was applied. In this case, the husband has disappeared and the wife had waited for the husband for certain amount of time. After that, the wife remarried. Now the husband returned few months after the marriage of the wife and charged the wife with an offense of bigamy, more than one marriage. In this case, the wife said she had a bona fide belief on reasonable grounds in the death of her husband at the time of second marriage. Thus, she did not have any intent of committing the crime and hence she was acquitted. Then one of the important case laws in Indian context is R. Balakrishna Pillai versus State of Kerala. Here it was observed that criminal guilt would attach to a man for violations of criminal law. However, even if we are applying the criminal guilt, we are looking for mens rea. The rule is not absolute and is subject to limitations indicated in the Latin maxim, which is actus non facit reum nisi mens sit rea. It signifies that there can be no crime without a guilty mind. तो इस केस में ये बोला था कि अगर कोई भी क्रिमिनल लॉ वायलेट होता है तो क्रिमिनल गिल्ट माना जाएगा, बट ये एब्सोल्यूट नहीं है. एक गिल्टी माइंड होना चाहिए क्राइम एस्टैब्लिश करने के लिए एंड इट शुड बी प्रूव्ड. Then another of the important case laws are Gajraj Singh versus State of Rajasthan or Siddhapal Kamal Yadav versus State of Maharashtra or State of Rajasthan versus Shera Ram. In सभी cases में there was a plea of insanity. Section 84 of IPC, which is an exception with respect to insane person. Here the principle of actus non facit reum nisi mensit rea was applied and it was said that Section 84 embodies the fundamental maxim of criminal law, actus non facit reum nisi mensit rea. In this case, the court emphasized on the fact that a person of unsound mind or a person suffering from mental disorder is devoid of this basic norm of human behavior, that the person should not murder someone. That means mens rea is absent and hence in case of insane person, he cannot be held guilty of a crime he does not even know he is committing. So if there is an insane person of unsound mind, he can use the exception of the absence of mens rea. But there are certain exceptions to this principle. अब इस principle में हम लोग बोल रहे हैं कि criminal act के लिए criminal mind, guilty mind होना compulsory है. But that means a person can plead absence of mens rea, that I did not have guilty mind, गलती से हो गया, private defense में किया है. पर लेकिन एक एक्सेप्शन ये है कि ignorance of fact can be established, ignorance of law cannot be established. Ignorance of law, mistake of law cannot be considered as an excuse to commit a crime, as every citizen or non-citizen is expected to know the law of the country in which they are or they are visiting. फॉर एग्जाम्पल एम एच जॉर्ज केस जो हमने अपनी लास्ट लीगल मैक्सी में पढ़ा था, इग्नोरेंशिया ज्यूरिस नॉन एक्सक्यूजाट. ऑल्सो देर आर सर्टेन ऑफेंसेस जिसमें स्ट्रिक्ट लायबिलिटी मानी जाती है. Strict liable offences are those offences where the prosecutor does not have to prove that the defendant acted with a guilty mental state, since the act itself was enough to prove the crime. For example, in section 375 of IPC, which talks about rape, that is sexual intercourse without consent. In this case, even if the mens rea is absent, the physical act is enough to deem a person guilty under this section. So in crux, we can say in order to establish a criminal offense, both criminal act and guilty mind should be present. Now let's move to today's situation. A is a person. He has asked a child, B, who is 6 years of age, to add some liquid to the glass of milk of C. The content that is added is poison. As a result, C dies. Now, will A be liable? Will B be liable? And guess to which legal maxim this situation relates to. At iExamB, we provide online courses for preparation for a lot of law officer exams. iExamB is your one-stop solution for all legal exam preparation. If you are interested, you can check out the demo of these courses from the description below. For any queries, you can write to us at hello@iexambi.com or call us on this number mentioned on the screen. Subscribe to our channel to stay tuned with relevant exam notifications, content, legal current affairs, strategies, study plans, so on and so forth. Thank you.